Okay, today I have been asked to speak on this topic neurosurgery and law, an intersection. Well, as we are terribly running behind the schedule, I would try to be as quick as I can and try to say these are the three very important aspects which I would be touching upon. The first one is I would try to present a litigation profile as to how neurosurgeons are today litigated. And second one, the legal framework that is applied to neurosurgery in particular. And I would try to draw some conclusions and then we can think of some take home points. Well, why I need to do this? It is because when you are talking of neurosurgery and intersection with law, it is pretty much so vast a topic. Anything under the sun can be brought in here. That is why I thought I will just try to talk about this. When you are talking about litigation profile, I have just mentioned the three, what you call as works or three papers that were published in the last 2 years. And I have studied nearly 16 such papers which were published in the last, 5 years. And that is one part of the story. It is more or less trying to, capture how you have been litigated against and the success rate, so on and so forth. But to tell you very clearly, one good thing, the organizers contacted me almost, 2.5 months back. So that gave me the opportunity to prepare myself and I could go through the, Supreme Court, High Courts, as well as NCDRC, that is National Commission, situated at Delhi. And there are totally 46 what you call as cases involving neurosurgeons. But these papers, very interestingly, what they try to do is they indicate that there are 35 litigations. I'm not on the point whether it is 35 or 46. Let me just tell you, against the population of neurosurgeons and including neurologists. See, even if you take what statistics I am saying, 46, please let me tell you, it is negligible. Because today what is happening, I only wish there are no hardcore lawyers in this particular group because they will certainly outcast me. Because we survive on that fear psychosis. No, so we spread that fear psychosis. As long as you are under the fear, constant fear, that any time you may be litigated against, I would lose my prominence. But if you really look at the data and what you call as crunch the data, there is not significant what you call as threat as such. That's what I will come to. See, but if you really come to these 5 points which I have mentioned, majority of the cases were filed against the neurosurgeons and remaining were against neurologists, that is 65%. And spinal injury cases are considered to be the cases where popularly people have gone, that is approximately 12%. And doctors were found guilty of negligence in about 40.6% of the cases. That means majority of the cases you people have won. And that also I will tell you how, this entire statistics needs to be really understood in context. I do not know how many of you are aware, every single case decided by the Supreme Court or every single case decided by the National Consumer Commission is reported. There is some system called reportable. Because when I decide a case, I will stamp it saying that please go ahead and report it. So it is not necessary that every single case against a neurosurgeon or against a doctor which reaches to any of these forums get reported. That also you have to understand. And only those cases which the presiding officer or the court feels is very important and stamped as reportable, that gets reported. So that is where I am trying to tell you the data indicates it is not considerable amount of a threat which is there. But I leave it to you rather than me prescribing. But this is slowly becoming larger. Because if you profile it against the time, the entire litigation against the time, if you see 5 years back, absolutely there was no litigation against, neurosurgeons. But it started probably after, 5 years. Before that, not having a neurosurgeon in some of the complicated cases by other, surgeons was considered to be negligence of the doctor. From there, now neurosurgeons and neurologists are being sued. So if you look at that trajectory, probably it becomes alarming, and probably you should pull up the socks today and try to, prepare yourself from now on. Maybe I will come to that also. And post-operative complications were the major causes of litigation, and total number of cases involving neurosurgeons and neurologists is 35. I have just confined to that. I did not include 46. So now I will come to the legal framework applied to neurosurgeons. According to me, it is a very important slide, and I wish to spend little time. See, first and the foremost, every time I was calculating because I had come to my hometown, no? So my family is still there, whereas I'm working there. My wife was counting and telling me that this is the 8th Sunday I'm away from the home. Because every Sundays, typically you will have one or the other, what you call as conclaves like this, CMEs like this, and the doctors do include me. And I also, as far as possible, I do not say no to them. I go there because this is my area of work, and I get to meet lot of doctors and things like that. That is a professional advantage. I do not really say no to them. But whenever people of speciality call me, they generally try to say, "Sir, you talk about our speciality and law as you have pushed me now." But I'll tell you, the principle of law remains the same, whichever may be the specialty. For us, we don't really go by your specialities and super specialities. We simply apply this principle called A, B, and C rule, which is there on the slide. A is a duty of care. That is, you owe duty of care, and you breach that duty as a as a consequence of that breach of duty. There is an injury or a damage. Injury, don't think it is only physical or in your sense. It is breaching somebody's legally recognized right. That is what we call as injury. So if these three A, B, C's are ticked in affirmative, I would hold the doctor liable. If you think it is very complicated, ladies and gentlemen, I have eased it out by saying if this principle is applied to doctor-patient relationship, how we try to really look at? We try to ask these three questions. Whether doctor owed a duty of care towards the patient. We ask that questions. If the answer is yes, then we go, did the doctor breach that duty of care? And finally, whether that breach caused damage or injury to the patient. If all the three questions are answered in affirmative, we hold the doctor liable. But the most critical point here that you need to understand more than the principle is, it is duty of care, not duty to cure. So whenever you have a patient complaining, "Sir, I did not cured of my morbid condition," or death occurred, don't even, don't just think, "Oh, you would be held liable." As long as you demonstrate to the judge or to the court or to the forum that you have done what a reasonably ordinary or reasonably prudent doctor situated in similar circumstances would have done. So the whole game is to show to the court how reasonable you are, how complying to reasonable standards you are. And second very important point, wherever I get the opportunity, maybe I would steal 1 minute of your time and tell you, see, I'm a judge. I don't understand the complications of medicine. So I hear both the parties who, paint the picture before me. And by that, I comprehend, okay, this is the standard of care line. And then compare whether doctor has met that standard of care or not. That's all. So it has to be played like a, whether it is game of a cricket or a soccer. That's all. So how you convince the judge that you are being reasonable will ultimately, steal the show, or that party wins the case. So if you really ask me, I don't know what happened. Okay. See, this is the legal framework applied. Sorry, I think the cases where doctors are held to have breached their duty of care. One is where they fail to follow reasonable, what you call as standards. If I'm told as a judge, sir, they should have immediately, submitted me or driven me or wheeled me into the OT, but they delayed it substantially. Then the judge would ask, any reasonable neurosurgeon would have waited or would have really immediately done the surgery. Not doing the surgery, having accepted the patient for treatment, is taken to be unreasonable act. I'm just giving a very simple example. Much more examples can be given on demand. When they perform without valid consent. This is where I think I needed to take a minute. Many a times I'll tell you, you have done what is expected to be done by as a doctor. I repeat, you have done whatever is expected of you to be done, and you are quite reasonable, and your treatment is successful. That means everything is to your credit. You have done what any other doctor similarly situated in the circumstances would have done. You have followed what is called as standard protocol, and your treatment is successful. But only glitch is you have done it without seeking the consent of the patient. Believe me, law condemns you, holds you liable. Although you have cured the patient, if he complains, yes sir, I am completely cured, but it was done without my consent, law will take an objection to that. That is why valid consent is the most critical one, particularly in your field. So then I will come to the take-home points. That is, neurosurgeons are sued. There are instances, but unlike others, there is something you need to be, tremendously worried about that. Like any others are sued, you are also being sued. There is no significant danger to the community as such. But you may say, sir, are you not contradicting yourself? On one hand, you are saying there is no significant danger. On the other hand, you are saying before, half a decade there were no cases, but now the cases have started. See, that is the behavior which you are seeing across the society. We are becoming more and more a litigious society. See, I stayed, just to take my own example, I will tell you, I got baptized into legal academia 31 years back. I joined straight away National Law School, Bangalore. That's what professor was, referring to. I served there 30 years. Absolutely, I had no intention of moving anywhere else. But because of certain circumstantial compulsions, I was asked to take up the leadership role in Calcutta. So I went there. My chancellor is Chief Justice of India. He asked me, Professor, I want you there. You please go. I went there. One of the important striking factors, we had nearly 17 cases against our own law school. That was one of the challenges. In just about, 4 months after taking, now I'm 7 months old there. So I could complete from 16, I could bring it to 2 cases. So that means law school 30 years, we have had no litigation against us. We had only two sundry litigations. One was from our student, second one was from our own employee. But the judges immediately said, in the admission stage itself, they said, see, I will mediate because it is not a good trend. So what is that I am trying to say? The sum and substance is we are becoming litigious society. So if you wanted to give weightage to that, sir, 5 years back there was no litigation, now litigation has started, it is going to increase. Yes, it is going to increase. But is it alarming? According to me, it is not alarming. It is not contradicting, because this is how the future is going to be. Whether you like, you don't like. The second one is, the third one is, more than half of the reported cases are in favor of the neurosurgeons or neurologists. See, that probably tells me you are much more disciplined in comparison with other specialities or super specialities. I hope you are getting my point. And why you are being litigated, that is post-operative complications, lack of informed consent and delay in treatments, etc. are some of the underlying causes why you have been dragged to the court of law. See, here I would try to really tell you something. These, according to me, are the take-home points. The first one is, communication is the key. Had I had the time, I would have shown my, what you call as notes which I prepared for this, conference. All those 46 cases which I studied, my notes indicate it is hyped, what you can say, expectations that were created among the attendants of the patients. Doctors gave them a rosy picture as if he would be wheeled into the OT and he would be wheeled back and everything will be all right. Well, many doctors, because believe me since last 24 years I am working in this particular area, that is area of health law. Doctors do say, sir, we can't be like robots saying that there are 25% of 25 chances that you may not wake up at all. See, we can't. We have to be very positive. If I am very not positive, in my case, the patients will collapse. That is why I have to be somewhere discreetly balancing it. That is an art. Rather than me telling you what is that art, you need to really. That is why communication, according to me, is very key. Second one is, be positive but moderate in your, assurances. Because most of the time, judges are influenced, especially those 40% of cases where, you are held liable. The judges relied their, what you call as base. They based their verdict saying that, oh, you have given them this kind of a picture, and later on their expectations are dampened. Because please believe, judges are also human beings. Because they generally try to see, if I were to be that patient, or if I were to be the patient's attendant, if somebody tells me so convincingly or confirmingly, sir, डरने की कोई जरूरत नहीं, everything would be all right, I would have rather, jumped to take the same decision, is it not? And then obtaining proper consent. Why I'll tell you, there are at least 8% of the cases, and all the 8% of cases have gone against because somehow judges doubted the consenting process. Because in your particular case, if not always, majority of the cases you operate, you operate through proxy consent, is it not? That is why consenting process is something very, very important. That's a subject by itself, if you ask me. So that is why, ladies and gentlemen, I have a roughly 1 minute's time left. I wanted to end with this particular note. If you think a decade back, 5 to 7 years back, there was absolutely no litigation against your super speciality, and today there is a litigation. We needed to be on our guard. If you think like that as a community, because I always believe, rather than me telling what you should be doing, you as a community of professionals should autonomously think. That is, according to me, is the key. If you think, yes, sir, this is one danger which is slowly, growing, then I would say try to have some kind of capacity enhancement programs in this particular area. Even I came quite at a time, I was listening to other speakers that was beneficial to me. Not that I am saying it in a reserving tone. See, it was quite beneficial. Everybody was saying, oh, this finance, let doctors have some kind of, knowledge about that. Somebody was talking about HUF, LLP, etc. So, law of organizations, it's very important because you are going to be now entrepreneurs also. Right? So having some kind of, let us say, a curriculum or having some kind of a module which would enrich how you can, develop those skills. That is certainly going to hold you in good stead. So I would take only 10 seconds. That is to thank the organizers, particularly Dr. Kiran, for inviting me and giving me this opportunity. I thoroughly enjoyed being here. Thank you.